This afternoon we're going to be talking about estate planning. If I had to pick one area that our clients are deficient in, it would be estate planning. Most people either have no estate plan or the estate plan they have is probably 20 to 30 years old and is completely outdated. So at a minimum, you need to have certain documents in place. The first thing you ought to have is a will. If you don't have a will, that's called dying intestate, and that means the state decides where everything goes. So the first step is to have a will. But more importantly, where we see a lot of our clients are near retirement is they don't have powers of attorney. Powers of attorney are very important because most people's largest asset is a retirement account. The retirement account, unbeknownst to most people, is not a joint asset. It is an individual asset, hence the term, individual retirement account. So if a person becomes incapacitated and they have a large IRA account, say a $500,000 IRA, the spouse has no access to those funds because that person is not deceased. They may be the beneficiary, they may get the money when the person dies, but if they're incapacitated, they have no access to those funds. So it's crucially important that people have not only financial powers of attorney, but healthcare powers of attorney as well. The last document people ought to be looking at is a living will. This is the end of life directive. What you want done if you are near death. Do you want water? Do you want medicine? You can direct those wishes, and it's important that you have these things in place. Now, if you wanted to avoid probate, probate is the court administrated process of transferring your assets. There's a couple different ways you can do that. Number one, any type of retirement plan with a beneficiary does not go through probate. So if you have a properly titled beneficiary, that will avoid probate. All you need to move those funds is a death certificate and a claim form. In addition to that, if you have other accounts that are not beneficiary named, if you have non-qualified brokerage accounts, mutual fund accounts, you can set up transfer on death, TOD, payable on death, POD. You can get those set up, they don't go through probate. That leaves the house. Probably the easiest way to transfer the house would be a revocable living trust. So when you set up a revocable living trust, you have to retitle the assets into the name of the trust. So if you had non-qualified brokerage accounts you wanted to get in the trust, you didn't want to do the TOD, you can transfer, you can retitle them into the trust. You can transfer the title of the deed to your house into the revocable living trust. You still maintain control. You are the trustee of the trust, but upon your death, nothing would go through the court process. It's a very seamless, easy transaction for your beneficiaries to make. Again, if you'd like to get your estate documents in order, we work with attorneys in the tri-state area, and we'd be happy to help you do that. Pick up the phone and give us a call. Have a great day.